Good day, ladies and gentlemen. My name is Mark Rollins. I'm an attorney here in Washington, D.C. I am a partner in the law firm of Rollins and Chan. I've been practicing in Washington, D.C. for about 16 years. Today I'm going to be presenting this brief overview of drinking and driving laws here in Washington, D.C. I'm going to get started right away. Okay, so in the District of Columbia, when they're charged by the prosecution entity of the Attorney General's office, there are typically 3 separate offenses that they charge with. And understand that each one of these is separate and distinct, that they do not have to just charge one or the other, they can charge all 3. The first one is the most serious, and it's driving while intoxicated. Language is not actually in the statute, but it's defined as driving while intoxicated with a BAC over 0.08. That's blood alcohol content rate is above, blood alcohol concentration is above 0.08. And again, it's the most serious of the alcohol-related offenses. The second one is driving under the influence, and what's required here is that you can have a BAC under 0.08, but the government has to show that you are appreciably impaired. And you'll find that operating while impaired, very similar to driving under the influence. The only difference is that they have to prove that you were slightly impaired. So you can see that operating while impaired is the easiest of the 3 to prove, as they only have to prove that you were operating the vehicle and you were slightly impaired. It also has the least penalty as well. So if we go through the actual statutes, driving while intoxicated, they have to prove that you were in operation of the vehicle. They have to prove that you had a 0.0 higher BAC, 0.04 for commercial drivers, and if you were under the age of 21, any amount of alcohol in your system. And for driving under the influence, they have to prove again that you were in operation of the vehicle, that you were impaired by alcohol or drugs, and again, appreciably impaired for DUI and slightly impaired for OWI. Now, again, DUI and OWI and DWI, you have to prove that you were operating the vehicle. And in meeting out that element, this is typically how they do it. It may seem interesting, but physical movement is not necessary in the vehicle. In a parked car with the motor running, they could prove that you were actually in operation of the vehicle. The case just came out that you can actually be on a bicycle and be in operation of a vehicle. You could be asleep in a car. And you could give a confession with not even being in the car, as long as they have some corroboration, a witness or somebody that saw you driving the car. Now, for impaired, they usually make this out by saying poor driving, and the officer or someone witnesses this: bloodshot, watery eyes, slurred or mumbled speech, fumbling for driver's license, not responsive, using car for support when exiting the car, swaying when out of the car, field sobriety test. Now, field sobriety test, you can go. This could be a separate video all to itself, and so I just listed it as one of the ways of proving that you're impaired. And again, the roadside breath test, which is not, it's admissible for probable cause hearings. And again, opinions of lay witnesses. Now, to prove that other element in the DWI, all they would have to prove is to show that you blew a 0.08 or greater. And how they do that is basically bring in a certification that the machine was found to be accurate within the last 3 months. And the test was conducted according to the manufacturer's specification. Now in D.C. they've had some problems with this, as you may have heard in the news in the last few years. And I think recently they have just reinstated their policy on these breath tests. Now this is the big one, and I know most people want to know what the penalty is for DWI, and this is the big one, because these just recently went up, and for the first offender, 180 days and a $1,000 fine. Now that used to be 90 days, and they went up. You're still not entitled to a jury trial for a first offender, but for 0.20, if you blow 0.20, it's a 10-day mandatory minimum, which means the court must impose that 10-day mandatory minimum. 0.25, 15-day mandatory minimum. 0.30, 20-day mandatory minimum. 15-day mandatory minimum on these Schedule I drugs, phencyclidine, which PCP, cocaine, methadone, or morphine. For a second conviction, DWI, within 15 years, it goes up even more. You're facing a maximum exposure of not more than 1 year, so you would be entitled to a jury trial here. And then you have their fines as well, mandatory of 10 days as well. For 0.25, 15-day mandatory minimum. 0.25, 20-day mandatory minimum, 0.30, 25 mandatory day minimum, and there's a 20-day mandatory minimum. That should say 20-day mandatory minimum for blood or urine contents of Schedule 1 drugs, again, phencyclidine, PCP, cocaine, methadone, morphine. Penalty for DWI, 3 or more within 15 years. No less than $2,500 and no more than 1 year, so you're still facing that 1 year. The fines have gone up and the mandatory time has gone up. 20-day mandatory for 0.20, 0.25, 25 mandatory minimum, 0.30, 30-day mandatory minimum, and then again 25 mandatory minimum for those phencyclidine, cocaine, and methadone, and morphine, if those are in your system. Now, fourth-time offenders get an additional 30-day minimum for each prior offense. The penalty for OWI, which is again the least one that they have to prove, that still stays in that 90-day or $500 or both. But repeat offenders, 1 year, both with a mandatory minimum of 5 days. 2 more priors, $1,000 to $5,000, 1 year, both with mandatory minimum of 10 days. And there is an additional mandatory minimum of 5 days for the driver's license of a commercial vehicle. And then they've also bumped up the penalties for children in the car, minors 5 days per child, if they're in restraint, 10 days if not. And then you have the $500 fine and $1,000 per, up to $1,000 per minor. And then you have, I'm not going to list that one, but that's watercraft. That doesn't pertain to too many people here in D.C. But this is the biggest part. All is not lost, and I don't want you to think, I know I seem like Debbie Downer, especially when I don't want to end on the penalty phase of this. What you want to do is you want to get a good lawyer, and the challenge, every one of those elements can be challenged, from the operation of the vehicle to whether the person was impaired, and even the actual breath test can be challenged. Call us today. We'll talk about it. We'll sit down. We'll have a meaningful conversation, and I'm sure we can help you. Thank you.